Evening to one and all present here. I, Shikhar, along with Pratham, my co-moderator, extend a very warm welcome to the sixth session of webinar series titled as Making a Career in Institutional ADR, hosted by the Center for Mediation and Conciliation, Bombay, and Center for Arbitration Dispute Resolution, RGNUL. The aim for today's session is to understand the working of MCIA, what institutional ADR is, alongside having a tete-a-tete on the position of institutional arbitration in India. It is an absolute privilege and honor to have an inspirational figure like Ms. Neeti Sachdeva ma'am here with us, who started her career as a deputy arbitrator at LCIA, then had stints at the economic laws practice and at the trilegal as senior associates, and finally being the Secretary General and Registrar at the Mumbai Center for International Arbitration. Before we discuss about your fascinating arbitration journey, ma'am, which started at GGS IPU, of participating in the WIS-Vienna arbitration competition, further going to Stockholm University for your master's, and initiating your arbitration journey by giving shape to your enthusiasm in arbitration, and finally carving out a professional career for yourself. We wish to know, how does it feel like to be having so many feathers in your cap?
I don't know if you can really call them a lot of feathers in my cap, but yes, it's been an exciting journey in that sense.
Of course, ma'am, it is. So, Pratham may take over.
Thank you. So, ma'am, it is safe to assume that everyone in our presence here has witnessed your achievements and maybe stalked your LinkedIn, or at least Googled you to know better about you as a speaker. So my questions to you then would be extremely uncalled for, but necessary at the same time. So the first is, then, who is Neeti Sachdeva and what does she do for a living?
I just hope that they Google and did not get any photographs of mine or any links of mine, which I would not want people to see. So I'll go and Google myself now on this time.
Yes.
But who is Neeti Sachdeva? I would say that I'm an eternal optimist and an institutional arbitration enthusiast. That's how probably I would define myself, more of course in my career path of it. I am somebody who enjoys what I do. And I don't think that I've ever felt even for a single day that I have to go to a job and it's a drag. So it's just been that I think arbitration has been my hobby along with being a career choice that I've taken.
That's great, ma'am. That's very nice to hear. So, ma'am, I want to know, what are the roles and responsibilities of a Secretary General and Deputy Registrar at the Mumbai Center for International Arbitration?
Sure. So, see, of course, MCIA, there are other arbitral institutions in India. They have existed for a long time. But I think MCIA is one of its first kind international arbitral institution, which was set up in India. The idea really was to give a world-class arbitration facility and rules to the Indian parties that they don't have to think about resolving their disputes outside of India. I mean, all of you, you're listening and both of you with me here would agree that India probably has one of the best legal minds that are there. So then what is the reason that we would have disputes which go outside of India? So that was the reason with which the MCI was really created, structured. And I wear double hat in that sense. And at some point in time, I hope that we will, be able to bifurcate the two hats and have another person joining in at that level. So as a Secretary General of the MCIA, the role is more to promote the institution, to talk about what institutional arbitration is all about. Of course, in India, it's unfortunate that even today we have almost about 60 to 70% of disputes resolved through ad hoc arbitration. And people who have been in the dispute side as well, practicing disputes, sometimes when you interact with them, they do not appreciate what does an institution do? What is an institutional arbitration, right? So as a Secretary General, that's my role, to make sure that in a very loose way to educate people about institutional arbitration and to promote, of course, MCIA as well and the rules. The different hat that I wear is of a registrar, which has a very specified role under the rules itself, the MCIA arbitration rules that we have. So right from, coordinating, I would say, from the council to the parties, playing a role in the appointment of an arbitrator. Of course, it's the council of the MCI who appoints it, but I head the secretariat as a registrar. So there's always an interaction which happens when a new matter comes to us. Then, of course, making sure that the arbitrators, give an award in the specified time, there are no delays. And at the last that we have is a scrutiny of an award. So MCI has a very light touch scrutiny. When an award is, drafted by the tribunal, that's sent across to the secretariat. So it's under my responsibility to make sure that there are no, apparent lacunas on which the award can get challenged, more on the procedural side of it. Of course, I can't do all of this without a team of case managers. So we do have case managers, and that's how the two roles are very distinct from each other.
Thank you, ma'am. So my question in furtherance of this would be, why did you choose to work in this admin job?
Okay, very difficult. So I'll tell you this. While Shikhar was introducing me, he said that I was in the Guru Gobind Singh Indraprasth University. I was a part of the first batch of the law school. We started at Kashmiri Gate. And, I think it's great to be the first batch in certain respect, though you're the guinea pigs. And we had to see through a lot of problems, of course. But also we had the advantage that we could be experimental. So me with some of my colleagues, we were avid mooters, and we heard about the Vienna moot. So, literally we went to the university and said that, listen, we need some funds. We need to go to Vienna. And our university is like, no, we don't have the funds. Think about it. Do it yourself. And then we'll see from there. I still remember that we didn't even have an arbitration book in our library. So me and my colleague at that time, my friend at that time, we shipped in a book from London, which was Martin Hunter's book on international commercial arbitration. And I even tell today anybody that if arbitration is your field, please make Redfern Hunter as your Bible. It's just wonderfully written book, which, clarifies all your concepts. And then we started to download material on CISG. Everything was available on website and all, and we started to prep for it. October is when the problem comes, and February, March is when you are in Vienna, right? So those 4-5 months, I think we did nothing but just eat, breathe, smile, cry, arbitration. That's all that we did. And we were, of course, one of the finalists at the moot. So I think that was a time that I realized that arbitration was my calling, and that is what I love doing. Now, why in an admin job, of course? So I was with Freshfields in Paris, and LCIA India was opening its office in India. I remember when I first wanted to work in India, some of the senior counsel said that, if you want to work in international commercial arbitration, get out of India. There's nothing happening in India. So LCI India was a great opportunity to be back and to create a culture which did not exist. Of course, it's long back, 2009 was it when it was set up. So it was just for me to be like homecoming, and I didn't mind doing a work with the institution. I enjoyed it. Of course, I was there with them for about 4 years. And then I went on to my journey of being a counsel. You sometimes miss, right? You're not representing clients. You're not trained as a lawyer to be doing the admin job. So I had my stint with ELP, I had my stint with Trilegal, which was very interesting. And then the MCI was being set up. It's a homegrown first kind of its international arbitral institution. And the challenge really was to popularize it, right? I don't think many people get an opportunity to create something grounds up and hopefully leave a legacy that others can follow. So though it's an admin job, but not really, I see myself doing very many different things. I teach at universities, I sit as an arbitrator. So I'm very closely associated with arbitration in other than the admin job as well. But it's just to be associated with arbitration. That's all that I know. I always say, I know nothing better.
That was a beautiful journey, ma'am. And in this regard also, so what are the services that the MCIA provides, and what are the significance of these services?
So right now, of course, we are only have the arbitration rules. We don't do mediation yet. That's not what MCIA started. As an arbitral institution, parties have, I would say, 2 ways that they can approach us. One is that when they're entering into a contract itself, in the dispute resolution clause, they can agree that if a dispute arises, then they will refer it to MCIA. And MCIA, of course, has its fee of schedule, which is available online. There are no hidden costs really there. What the arbitrators charge, what the MCIA charges. So right from your appointment of an arbitrator to making sure that an award is, delivered by the tribunal in the shortest span possible, and delivering an award to the parties. That's a full service that we provide to them. Of course, in between, if parties would want, services like transcription, document management, then we do have third-party vendors whom we tie up with and help the parties with that as well. But out and out, I would say that MCIA will only help you from a notice of an arbitration to an award stage in the least efficient, in the least time consuming, but an efficient possible way.
Thank you so much, ma'am. I now hand over the stage to Shikha to proceed with the other questions.
Thank you, Pratham. That wasn't very difficult. I hope, Shikha, you continue with the same tone.
I would, ma'am. Ma'am, since your experience has been immense and terrific, you have seen a journey where arbitration wasn't doing that much, but now it is. And since now we have other types of institutions as well, apart from MCIA. So ma'am, my question here being, why does a country like India needs an arbitration institution in the first place?
Oh, wow. I thought you would have said that why are we so late in having arbitral institutions in a country like India? Why do we need, okay. Let me put it this way. See, we know that there are backlogs in the courts. Our court structure, as we all know, the pendency in the courts is immense. And for commercial matters and for a lot of other matters as well, what parties are looking is an efficient dispute resolution. See, especially in a commercial setup, it's not about two parties fighting because they have an ego to fight on or they have any personal animosity. It's just about a business going bad, finances not working out. So they need to get a resolution of their dispute and move on, right? The business continues. Now, if the parties have to get stuck up in the court for the many, many years that we see ourselves in the backlogs of the court, it's very difficult for the businesses to continue. So arbitration actually provides you a very efficient manner where you can have a speedy dispute resolution. Secondly, as you would appreciate, the kinds of disputes which we saw probably 2 decades back are not the same. We're talking about artificial intelligence and the metaverse and the blockchain and all kind of very technical disputes which come in now. Though of course our judges are great and they understand the law. I don't think anybody understands the law better than what the judges do. But at times it's very difficult for them to appreciate the nuances of how the industry is changing. So in an arbitration, the advantage is that you can have an arbitrator who has an expertise in that kind of a field. So let's assume there's a dispute with respect to a pharmaceutical industry, like healthcare industry. You may have somebody who's had an ample experience of 10, 15 years working in the healthcare and would appreciate that issue a much better way than probably a judge would do that. So those kind of disputes for sure. So I would say technical disputes like your construction disputes, your maritime disputes, in the energy power sector disputes, your pharma disputes, all these of them require a very different sort of an understanding, which in no way am I saying the judges don't have it, but I think technical experts can play a much better role. And that's why arbitration is important. Secondly, it's unfortunate again in India, we have not been able to follow it to the T. And I'm hoping that with a generation like yours, we will be able to do that. In arbitration, the strict rules of civil procedure code are not applicable, right? So you're not in that whole turmoil of applications, joinders, and then seeing more delays of it. It was meant to be something which is more akin to a quick fix dispute adjudication, right? So you don't have to be bound by the strict principles of law, while of course you are working within the framework of it. So that's why I think that for a country, especially like India and a growing economy that we are, disputes are inevitable, right? We all think, I say this a lot and people have heard me before may think that Neeti keeps repeating this, but I would still say it. When we are entering into a marriage, we never think of divorce, right? Similarly, when we're entering into a negotiation, a contract, it is to make money. We don't think of disputes, but they do arise. It's a human nature. It's the way that things go wrong. And when they arise, then, it is too difficult to go back and draft your clauses. So you draft your clauses on time, you have an arbitration as a dispute resolution mechanism, and then you are able to resolve your disputes in the quickest manner possible. That's why you need institution. That's why you need arbitration. To answer why institutional arbitration, very quickly, I would say is that see, institutions have a framework within which we work, right? We have a database of arbitrators. There are specialized case managers who are there. So, and the parties don't have to deal with the arbitrator directly. In an ad hoc arbitration, I think the two major concerns which arise is that if I'm a party concerned, and if you're a party concerned, right? And if an arbitrator is not, let's say, speeding up the process or delaying the process, neither of us would want to antagonize the arbitrator because he or she is going to adjudicate my dispute. But that's not the same with the institution. The institution really acts as a check and balance, I would say, to make sure that the process is run the way it is supposed to run. And that's why institutional arbitration. Sorry for a long answer, but it was very
No, ma'am.
difficult for me to concise it in less than that.
Not at all, ma'am. Ma'am, I think you with that told us the exact definition or why is an arbitration center is needed. With that, you told us the significance of institutional arbitration as well. So, ma'am, if you can cover that question as well, where you said, since it is so quintessential for a country to have arbitration as a mechanism in India, I mean, in any country. So why did we lack on that part, and why did it take so much of time for us to?
It's a very difficult question, Shikhar, I'll say. And I'll be honest with you, I have days where I still think about it, at why this has happened. I think there are two reasons for it, main reasons. One is that which is good reason as well, is that the faith of our general public in judiciary is immense, right? And we've all looked up to our judges, and we still look up to our judges a lot. So courts were always considered to be the go-to place to get a resolution. And if you look at probably about 50 years back, 60 years back, the kind of judgments that we had, which are still quoted, not only in India, but in Commonwealth countries. So I think it was just very natural that the parties felt it was just easy to go to a court. The thing started to change in 1996, I would say, or in the 1990s, when India saw a lot of foreign investments, opened up of economy. And when the economy opened up, we also saw a lot of cross-border trade happening. Now, when the cross-border trade happens, that is when that you need, I would say, arbitration more than purely even for the domestic sort. Because Indian party does not want to go to a German party. A German party would not want to get stuck up in an Indian court. So arbitration comes out to a very viable solution. Fortunately, unfortunately, we didn't really have any robust arbitral institutions at that time. Of course, as you may be aware, ICC remains one of the oldest arbitral institutions, but then they are also very prohibitively expensive for an Indian market, right? They charge in dollars, they have a different rates. And when you convert them into an INR, they become very expensive. So if you look at historically, our government contracts did have an ICC arbitration clauses. It wasn't that we didn't have an arbitration clause. But then because they became prohibitively expensive, it became much and much difficult for parties to even get a private adjudication done. And arbitration became a name that it is expensive, right? So you have a name associated with it that arbitration is expensive. And when it is expensive, people don't understand and appreciate it can be efficient as well, right? So there was a systemic change which made it more difficult. And then we had some Indian arbitral institutions which came up. But I think we again were not able to match ourselves up or keep up to speed with what was happening in the international market. So again, it didn't really help much in that sense. And I also think it's a problem. It's a human tendency that we are very resistant to any change. So when things are happening in courts, let them continue in courts. Why do you want to change them really? That is what I think probably are the reasons that arbitration didn't pick up that much as it should have. And institutional arbitration did not pick up for sure because probably we were not able to project ourselves as a country which has arbitral institutions of an international standard. While I say this, I must also say this, that it's very easy to criticize and to think of reasons, but also think it's very unfair as well to compare India to a Singapore or to London. I mean, if you are in Delhi or in Bombay, your South Bombay or your South Delhi are as big as Singapore. So Singapore could make itself a hub of arbitration, or London could do it. But comparing to India, you'll have to compare it to a Europe. And tell me one arbitral institution which has said that we cater to the entire Europe. Nobody does, right? So you need to have more than one institution which can cater to this large number of dispute resolution and do it in an effective international manner. That's what I would say, what lacked.
Understood, ma'am. Ma'am, I think your answer struck another question in my mind, and that is that how can MCIA be any time better than Singapore International Arbitration Center? Or if it is already better, then how is it so?
Good, you asked me the second part. Are we not already better? That is
Exactly.
that is what I would say. See, there was a very interesting webinar I was a part of, and I think it's available on LinkedIn as well. And I would encourage you guys to have a look at it, where we got the 4 arbitral institutions. We had the head of the ICC, LCIA, SIAC, and myself. And we were on a webinar where we were discussing that which institution to pick. I don't think it's about one institution being better than the other. There is enough work for everybody. It's only about what suits whom. That's how really the system works, really. If you are purely domestic, 2 domestic parties, I don't see a reason that why parties would want to go to Singapore and have the dispute resolved. Of course, parties choose. And if you look at our act as it was amended in 2015, and we said that we will resolve our disputes in 18 months, I think everybody internationally laughed at us and said that it's impossible. India does its disputes in 7 years, 10 years. How can you resolve in 18 months? And I think in the last 6 years, it's been a testament that we have done it and we've done it better. Our disputes are now resolved in 12 months, even in ad hoc arbitration. So it's not that we cannot do things better. It's just about a change, which all of us are ready to accept and move on. So I wouldn't say that how we can be better. I think we're already there. If you're talking to me a question, asking me a question, comparing us to SIAC, I think we're already there, right? Also, just to give you a statistical analysis, SIAC took 10 years to get its first case. And as I speak to you today, in 6 years, yesterday we got our 50th case. So it clearly talks about it, that how at steady pace that we are growing, right? But we want to take it, cement the market in India, take one step at a time, make that change of ad hoc to institutional, and then probably we will see where we are in the next 10 years, 20 years. SIAC already has 30 years under its belt. So we are very young in that respect.
So ma'am, since you talked about the 50th case, so if we may also get to know that who are the usual clients that come for arbitration, not just for at MIAC, but in other institutional centers as well. I hope that question doesn't breach the confidentiality which you have.
No, absolutely not. I wouldn't name the parties. I mean, some of them I could name them as well. MCIA, not MIAC. That's the first correction. So we are not SIAC, not MIAC. We are MCIA. But having said that, so I see that there are traditionally infrastructure construction used to be the area where you would see maximum number of disputes, and which still, of course, is. So, your infrastructure disputes, energy power disputes are the ones which are major. But what's definitely growing in the last couple of years we have seen is that shareholders dispute, and also a lot of, PE disputes, which are increasing. My sense is that the disputes arising out of PE and fintech is what is going to be the next that we see in arbitration. But traditionally, and in terms of the number and the largest volume in terms of the amount in claim, still is infrastructure and construction.
arbitration. So how would you assess the current situation of cases that are listed to be resolved by arbitration? But more importantly, how are arbitration institutions like MCIA helping in making things easier and better for the current scenario?
Sorry, you'll have to come back on that question. I didn't really understand. So as a council, yes. So how are you comparing? Sorry, come back on the question.
So ma'am, how would you assess the current situation of cases that are listed to be resolved by arbitration? And in regards to those cases, how is an arbitration institution like MCIA is helping in making things easier and better for the current scenario?
So are you saying that how the kinds of cases that are coming to
Yes,
arbitration now? Okay. So like I said, of course, that traditionally you would see very different kinds of disputes, right? A lot of contractual disputes of sale of goods and all would also be a part of disputes that you would get. Now you're seeing cases which are more, I would say, like I said, fintech disputes, PE disputes, shareholder disputes, a lot of very technical disputes also which come on, to arbitration. As an institution, what we do is that we have, of course, a panel of arbitrators. For MCI, of course, we have a database which is not published. So what we make sure is that depending upon the kind of a dispute it is, we have an arbitrator appointed who would have the industry knowledge to deal with that, right? So just to give you an example, if let's go back on the construction side itself. If it's a construction of a hydropower plant, and there's a dispute which has arisen between the parties with respect to its construction, then what an institution does is that we will appoint somebody who understands the engineering of it, right? A structural engineering of it, which people like you and I are not trained to have that. You need to have chartered engineers for that, technical guys. So we appoint them as an arbitrator, and then they can actually help their co-arbitrators to understand the dispute, not only from a legal side, but also understand it from more of a technical aspect of it. The practice of, having experts in terms of valuation, that has increased a lot as well. So these are the different ways I would say that, how institution plays a role. Of course, as an institution, we do not have a say in who your counsel are, how you are represented or who you represent. That's not something that we do. But what we can bring on the table is to make sure that you have a trained arbitrator who would resolve your dispute in the minimum possible time and understands the kind of a dispute that you have.
Ma'am, this is definitely a very important service that an institution is rendering, that is choosing the right arbitrator. So ma'am, I also want to know what is the additional role that is played by ICC and WIPO in the current scenario? And ma'am, what do they look for while hiring?
What do those institutions look for hiring? See, ICC, of course, please remember that ICC also is a part of the International Chamber of Commerce. So there's a very big, large mandate that they have, and arbitral institution is only just one of it. And like I said, they're one of the oldest, ones which are there. And they, of course, resolve disputes across border. They have a lot of disputes of that sort as well. And the hirings are usually, I would say, at the case manager level, when the people are starting off in an institution, where you're not actively involved in resolving the disputes or representing the clients or drafting, but your role is more to facilitate, like you had said at the beginning, an administrative role, right? So you'll be liaising with the arbitrators, you'll be liaising with the parties. There might be days when you're really doing, the economic side of it, in the sense of, raising of invoices, seeing that the money comes in, the parties are paid. All of those things is what an institution does. So anybody who's interested to have that kind of a role, I would say, is what the institutions are looking for. Of course, younger institutions like MCIA and some others as well, it's always an added advantage if you have somebody who's also motivated to be promoting the whole concept of institutional arbitration. So you get, to, I would say, market, reach out, explain, educate. That is what you can do. So somebody who's interested in that kind of a field, but of course understands arbitration as a subject, is what is looked for while in hiring. WIPO, for sure, of course, because it's a very specific niche intellectual property disputes that you're looking for resolving. So having a knowledge in that background is essential.
Thank you so much, ma'am. I guess Shikhar will take the next question.
Yes, I will. So, ma'am, if you can, hop us, all of us, into your time machine, and we go back to your college days when you were at GGSIPU. So, ma'am, what were those things which led you inclined towards the field of arbitration? With that, ma'am, you can also complement your answer with the thing that what are the positives as well as negatives of being an arbitrator?
So back to college days, first 3 years were fun, right? Like I said, we were the first batch. You've just gone to a college from a school. It's a different environment. You don't have any seniors, so there's no ragging. You're all having a fun time. And then reality hits you, right? When you meet your colleagues in the other law colleges and they're like, oh, we're doing this internship and that internship. And you're like, am I lacking something? Let's get on the bandwagon. Let's start exploring. So of course, I did a couple of internships at law firms wherever I could. But like I said, I was an avid mooter. That was something I really loved. And when Wismoot happened to me, I think at that time I knew that whatever I do in the field of law has to be something to do with arbitration. I wasn't clear what I would be doing, for sure not. In fact, after I completed my law, I joined as a law researcher with two great judges of the Delhi High Court, Justice Geeta Mittal and Justice Muralidhar. And there was a lot to learn from them, from the bench, that, how we lawyers think very differently, but what is it to be working on that side of it, and then how the bench thinks about it. But then again, I knew that I don't want to do corporate commercial practice. Corporate practice, of course not. I did not, because I wanted to be in the court, in the action, as they say. But litigation, of course, as being a first generation lawyer, we all know it's not one of the easiest things to do. And arbitration was something that I always thought was a very good mix, where you could do arguing, be a counsel, represent clients, but also you can manage your diary much better. You're not just at the mercy of the court giving you dates. Maybe, today you get a date to say that day after tomorrow you're supposed to appear in Hyderabad, and a few days later you're supposed to appear in Bombay or in Delhi, but you could manage your diary better. And then, of course, for that reason, when I went to Freshfields, this was a great experience to learn how do you represent clients, how much goes in the background study of it. And then with LCIA, India, it was a completely different field of law, right? You were not representing clients, but like I said, you were a part of a systemic change to do dispute resolution very differently. And that is how I think I've just stuck around. So, and I've been very lucky to be in the firms as well who have given me a platform of that sort. So when I was with ELP or I was with Trilegal, it was very clear that I just want to do arbitration practice. So it may be a section 9, 11 or a 34, but you're still doing something to do with arbitration. And I think that the firms today are also very happy that if you have a bent of mind of doing something in a certain way, they support you in that sense. And then MCIA, of course, it's an arbitration another way. Now, as an arbitrator, I have been sitting as an arbitrator now for a few years. I've got appointments from high courts as well and parties as well. It's very interesting. It's very different. It's how you are trained to be in a law college, and especially in a moot court, to think from one party, right? If I'm representing a claimant, then I'm just thinking a case from their angle. Of course, I'm prepared from what the respondent may come up with the defense and how to argue the matter. But as an arbitrator, you really have to take a step back, and you're not a party's lawyer. You really need to think from what is being presented to you, right? And it is only from what is being presented to you that you need to adjudicate. And that can be quite a challenge. And I think that's why going through arbitrator training programs is helpful. So I'm, of course, a part of the CIRB as well. I sit on the India board of the CIRB. I've done my CIRB training course as well. I think that just equips you with certain skill sets where you can sit as an arbitrator and appreciate a matter, not just as a lawyer, but from both the sides, and do not have a preconceived notion of what the matter ought to be or should be. It's great. I think everybody should try and at least in their experience, sit as an arbitrator if an opportunity arises. It's a learning curve.
So, ma'am, you mentioned about SIAC's training program, as well as you have also pursued your master's in international commercial arbitration. Ma'am, what's your opinion on that? A field so practical like arbitration, would a master's course be beneficial more than any other thing? Or since you pursued best of both the worlds, you also pursued your training in CIR. So what do you suggest, ma'am? Should a master's be done in arbitration?
See how I'll be hypocrite if I say, please don't do it. I've done it myself. I can't say that way. But I always tell students one thing. If you have lots of money and you're not spending your parents' hard-earned money, then you have to take a choice on that, really, right? Arbitration or litigation is a field that you need to get into to practice as soon as possible. So if you can afford to get a scholarship, which I didn't have to spend money on my education. If you can get a scholarship, then please, by all means, go and do your LLM. It widens your horizon. You see things from a very different angle. The friends, the colleagues that you meet they stay with you for a long time. You understand and appreciate international law from a different perspective. It's important. But in the field of ADR, be it practicing in the court or doing arbitration, I would say that if you're going to be ending up spending about 30 lakh, 50 lakh, 80 lakh of rupees, you'll have to think about it. Because whatever you're learning there, you will have to start from scratch in the court. It's not going to help you in the court practice. You will still have to do your drafting. You will still have to learn trials and all in the trial court, right? So it's very good from an exposure perspective. It's very good in how you end up learning international stuff, living by yourself as well. So a lot of personal skills that you develop other than just your professional skills. But if you're going to be spending a lot of money, and which is, like I said, not easily available, I would probably give it a second thought that whether you should be doing it or not. Corporate is very different because corporate world works in a different work. You learn a lot outside, which you can implement directly while you're back, but not so with litigation and ADR practice.
So, ma'am, if you can spend a minute or two more on this topic, if you can remember your days from the Stockholm University, how did you spend them? And what's your advice on any person who's going to pursue that arbitration from Stockholm University, or for that matter, any other one?
So see, Stockholm University was a great experience. And I'd say that a lot of people ask me that why an LLM from Stockholm? When you know that Indian students usually like to go to UK or US, for obvious reasons that our laws are derived from UK. And US, of course, is a common law as well, right, that we follow. The point is that Stockholm University is one of the courses where we had only 25 students in our class, and we had 18 different jurisdictions represented. So I had students, my colleagues who were right from Germany, US, China, Azerbaijan, Lithuania. I would have never got to interact, to that many different jurisdictions and people from that many legal jurisdictions in one go. And that's why for Stockholm, for me, was the choice. Secondly, of course, I'll be very honest about it. I got a full scholarship. So I didn't have to spend money. It was just easier, right, on my pocket as well. And while I was doing my research about the UK colleges and all, some of them have great programs, but then I would say at least 50% of your class is Indian students still there. So that what I was looking at to getting was an international exposure. I thought I got much better at Stockholm than I would have got at any other university. Also, Stockholm University and now MIDS as well. While when I went for my master's, MIDS wasn't there. They didn't have the course. But Stockholm University probably was one of the only universities which had a dedicated program in international commercial arbitration. Whereas if you are in any of the other UK law colleges doing your LLM, arbitration is just one of the other paper along with your many other subjects. Now, which is good as well, because if you're still exploring what area of law you want to do, then you get exposed to very many different areas of law. But like I said, in fourth year of my law college, I knew that whatever I do has to do with arbitration. Stockholm was a very good choice. It's very cosmopolitan. People are lovely. The food is nice. Weather is nice. And everybody speaks English. So it wasn't even a difficulty where, you feel that you need to learn Swedish and, it's going to be difficulty. Not at all. And of course, my professor in charge, Patricia Schwanese, great lady. And, I think a lot of what I learned in my LLM in arbitration and my passion to continue with it, I have to thank her for giving me that, and exposing me to all of that. And that's why this. I think MIDS course, I haven't been a part of it, so I can't really comment on that side of it. But of all the people that have attended it, I think they're very happy with that course as well. They give you an exposure to investment arbitration also. But again, I think quite a large population of students there as well is from the Indian background. So again, it depends what you're really looking at when you're going for your master's, other than just the education, the kind of fellow colleagues that you meet and all. It has to be a mix of that.
Ma'am, I remember previously in our sessions, Advocate Garv Malhotra had stated this line, that before pursuing masters, you need to have a work experience. And clearly, ma'am, even you had the one, since you worked under the auspices of Justice Geeta Mittal and some other. So, ma'am, what's your suggestion on that? Should we work first and then apply for masters?
I think it's good. I'll tell you why it is. Because see, when you are in law college, which you are also in today, you know that how much we expose ourselves. You guys do a lot more to be doing webinars of this sort, and as well, you people are a very motivated bunch. We weren't, I can tell you for sure. So law college, you learn a lot of things, but maybe they're not really purely all from a practical perspective. A lot theoretical as well, which we need to learn. When you enter the profession, that is when you realize that professionally how things can be different. And what is it that you need to sometimes unlearn to learn new things? I wouldn't say that you should spend a lot of time in your profession and then go for an LLM, because you're almost in that, then run of mill, you're just working and then you're looking for your promotions and all of it. To take a break for education does become difficult. But I would say about a couple of years, a max, a year, 2 years is a good time to work. Get that exposure of how the practical things work, and then go for your LLM, because you end up learning a lot more. It's not just from a theoretical going to a theoretical, right? In fact, a lot of case managers who have worked with us, the previous 2 or 3 case managers, they have worked with us for some time and then have gone for their LLM. So clearly, I think that they have also felt that it was a good thing that they had some practical experience before they go for an LLM.
Understood, ma'am. So, ma'am, since after this, I mean, if you can just this is coming from those students who are pursuing or trying to pursue masters in the field of arbitration. If you can suggest a particular specific subject which is booming right now or which has its scope in arbitration.
See, if you're looking at a career in arbitration, there's only one thing I say: please do a lot of trial work. People don't appreciate this, but of course, see, Delhi High Courts or your Supreme Courts are mostly appellate courts. Of course, Delhi High Court has original jurisdiction as well, but High Courts are usually appellate courts. Arbitration is not appellate work. Arbitration is hardcore trial. You need to have those documents. You will be cross-examining your witnesses. So you are doing a trial work. So if you can actually spend a couple of years in doing the trial work, and you can learn trial work only by doing it. No amount of webinars, videos are going to help you until and unless you get on a stand and cross-examine a witness. So if you are very serious about ADR or pursuing a career, let me not say ADR, let me talk about arbitration, because mediation is a very different skill set again. So if you're looking at a career in arbitration and litigation as well, you should do at least a couple of years of trial advocacy, trial work, get your hands-on experience, and then you start taking your arbitration briefs as well, right? Other than that, I'm just thinking, if an arbitration that you're looking at as a counsel, of course, be ready to read, read, and read. It's very easy to become a lawyer. Everybody says that. It's not difficult. We have all cleared our exams and we know how we've done it. I think it's very difficult to do anything post that. There's a lot of reading and writing which goes into it, and which you need to spend a lot of time as well. So that is what you need to concentrate on. And don't become too specialist. Please remember, arbitration is just a procedure. It's not the substantive law. Even in arbitration as a counsel, you need to apply companies law, you need to apply Sale of Goods Act. So 3 acts, which I would say that you should probably be very confident of if you're doing in the arbitration field, is your contract, evidence, and of course the Arbitration Act. And then there are other laws, of course, along with it, depending upon, like I said, if it's a shareholder dispute, you will end up looking at a Companies Act. You have to be well aware of it. So don't become too specialist in the beginning itself. Give yourself some time before you develop a niche area within arbitration as well.
Understood, ma'am. So, ma'am, as per you, these 3 or 4 laws are the ones which will form a base for us, and then we can pursue as per our the choices which we make. Either we can go towards the maritime arbitration or the energy sector, right, ma'am?
That's right. I mean, see, energy, again, a lot of contractual things, right? You will need to know the base of the contract with there. Of course, maritime becomes very different. So admiralty law, which is very different. The shipping laws are very different. But again, the bases remain the same, right? You need to understand the arbitration as a procedure. And then those are the specialized laws that you have. I would not recommend at this stage for at least the young practitioners to super specialize themselves so much to say that I'm only going to do maritime arbitration. There isn't that much work, at least not in India, right? You need to earn your bread and butter as well. So you have to keep your options open. But of course, you can start writing, attending webinars, speaking at webinars in that particular field of law. But arbitration practice, generally contract and evidence are your basis for it.
Understood, ma'am. So if Pratham may take over.
Thank you so much, Shikhar. So, ma'am, I think this is also a question in the chat box. So, what are the working opportunities at MCIA, and what does the institution look for in new recruits?
See, working opportunities, of course, we're looking for enthusiasts who believe in the concept of institutional arbitration. Opportunity remains, of course, at the law school level, it's the interns. We do hire interns. Internships are there for you to apply. We usually prefer for people to stay back for at least 2 months, a month to a 2 month, because 2 weeks, 3 weeks is a very short period of time to pick up anything. We usually encourage people in their 4th year or 5th year to apply for internships, again, for the reason because you have an understanding of the Contract Act at least, so you can appreciate a lot more. Also remember, arbitral institutions give you a very good platform to interact with the seniors in the profession. So if you're in your 4th year or 5th year, you have the law firm partners, you have the arbitrators who are coming to the institution. So you'll get an opportunity to interact with them, and probably that will open up the doors for you for an employment as well post your law college, which you're in your 1st year or 2nd year may not be really that helpful at that stage, maybe for your internships. In terms of employability with MCIE or any other institution, it's the case managers usually we are looking at. And like I said, that anybody who applies for us to be a case manager, please remember you're trained to be a lawyer, but you are not representing clients. So do not come to an institution with very many other thoughts that you will be representing clients, going to the court. It's a lot of action. It is not. It's a lot of mundane work, sitting on a computer, drafting letters, liaising with clients, liaising with the arbitrator, which may be quite boring as well at times. So I don't want to paint a very rosy picture here and say it's very exciting all the time. But yes, of course, you end up doing a lot of outreach programs. You're a part of webinars. Like I said, you get to interact with only a lot of senior practitioners in the field, your senior counsels, judges, senior law firm partners, which you don't usually get if you're working in a law firm. So that is how I would say is what an institution looks for. But if you are not motivated enough to be championing the cause of arbitration, institutional arbitrations are not for you.
Thank you so much, ma'am. And the last question is, what is next for you and NCIA, and what can we expect in the coming future?
That you're not going to ask me a question of how MCI can be better than SIAC, and where we can say that, not only MCIA, but India is now the hub of international arbitration. And anybody who wants to resolve a dispute, not only in Indian parties, but even the foreign parties, can very confidently come and say that we have the best of the legal minds in India. Let's resolve disputes in India. What's for me? I do not know. Life has never planned out ever the way I've done it. I didn't think I'm going to be in institutional arbitration. I didn't think I'm going to be with MCIA, but I hope wherever I am, I'm still doing something to do with arbitration. That's the only hope that I have.
So, ma'am, we give the floor to you lastly for spreading whatever message you would wish for our attendees to know. And with that, we would also thank you from the bottom of our hearts for your time today. So, ma'am, any message for the attendees?
Thank you so much. I think you should not take your life too seriously. Take arbitration seriously. Things just plan out. We all think that we're going to get out of a law college and then we'll have a job and then we're going to be doing this and all. Just don't take it too seriously. Things just happen. Take every experience as you grow, right? And I think the only one thing I have to say to the law students right now, money will follow you. Please don't follow the money. If you're dedicated in any profession, you're bound to be successful. So that's the only two things that I have to say to you guys. And all the very best. And thank you so much for having me. I really loved interacting with all of you.
So thank you so much, ma'am. If Shikhar wants to say something.
No, I just felt that this interaction was so amazing, ma'am. And I would really hope that I can get connected to you on LinkedIn, and there I can also get to see your experiences. Thank you.
Happy to do that. Please do connect. Great. Thank you so much and have a good weekend.
Thank you, ma'am. On behalf of CMC and CADR General, the managing crew and the audience, I extend a very hearty vote of thanks to Ms. Neeti Sachdeva for gracing us with her ingenious knowledge and expertise. And we are enthralled to be part of this session. And I wish there were less time constraints so that this Q&A session would go on for as long as possible. We are grateful and pleased that you accepted our invitation to conduct this session and coach the students on the various facets of institutional arbitration. And we appreciate you also for hosting such a lovely and educational session. And we look forward to working with you again to host more sessions like this. So we would now like to call the session to a close. We hope that you all enjoyed this session and were able to derive helpful knowledge and perspectives. On this note, we conclude the session and look forward to meet you next Saturday for our next session. Till then, a big thank you and stay safe.
Thank you very much, guys. Bye-bye.